and one case is a second-degree felony, and the other case is a third-degree felony. And I'm assuming no. Okay. All right. Court is calling 2025 CR 000240 and 2025 CR 013090. State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All right, so the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case, and when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child, and it appears that you have changed your life. And defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they are able to accept her in and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want you, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed, but the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee-high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed. And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, she was going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS, she's been compliant, she's been enrolling programs, she's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off, she's not fled, she's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for a very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony, I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, John?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, sure.
All right.
Judge, on the second-degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the unlawful, we're off the record, on the unlawful possession of the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you will be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
And Ms. Abrams, on Ms. Settle's, defense counsel has told me that felony drug court will accept her. And counsel, is she currently on GPS?
Yes, she is, Judge.
All right, we're going to continue with the GPS. Yes.
The case ending in 240, are we proceeding on count one or
Let me see. They're proceeding.
Okay.
They're proceeding on count 2 as a repeater. I'm sorry, wait a minute. They're proceeding on count 1. They're waiving count 2 in the repeater.
Judge,
Yes.
here's that docket back and we initialed the plea bargain change.
All right, thank you, Hunter. All right, we're back on the record. Is there anything else from either side before the court enters its orders?
Nothing from the state, Judge.
No, just that we have no objection to the change from the cap 6 to the cap 10 here.
All right. Then in cause number 2025 CR 000240, the court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
Just one moment. Deputy Laura, are you okay? Thank you. All right, there's to be no contact with Rudy Rodriguez. There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please, no contact, did you say no harmful or injurious?
No harmful or injurious contact with PECK, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state judge.
Nothing from defense, Your Honor.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. And that cause number, did you review it with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Next, we're moving to cause number 2024 CR 01309. All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days. No employment as a home health care provider or with minors. 200 hours of community service restitution. The court will show that 100 hours is satisfied upon the completion of parenting classes. GPS, and I'm sorry, probation will do partial GPS for employment and treatment in each cause number. Waive GPS fees. This is run concurrent with 2025 CR 000240 and referral to felony drug court. And again, if felony drug court for some reason does not accept her, she's to come back to this court. Probation, is there anything else with regards to sentencing?
This on the other call number as well, field visit.
Oh, thank you so much. Field visits one time per month until further notice.
And can you clarify which count on that call number?
The one I just read, the unlawful possession.
Yes, sir.
They are proceeding on count 1 and they're waiving count 2. Is there anything else with regards to sentencing in that cause number?
No question.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Here's the thing. You say you have a new child. Your counsel has told me you have a newborn, that you have finally, the haze has been cleared and you're finally going to do what needs to be done. In each of these cases, in one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself two questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you, Judge.
Thank you. It's always great seeing both of you guys.
You too, Judge.
All right. Thank you.
Thank you.